And for the defense, I appear with Mr. George Ouma and Ms. Eva Kala.
That is brought under Articles 27(1), 43 and 49 and 50 of the Constitution and Section 123A of the Criminal Procedure Code and all enabling provisions of the law. The grounds in support of that application are found on the face of it and on the supporting affidavit shown by yourself on 16th of September this year, and a supplementary affidavit by yourself on 26th of September, and also oral submissions by your counsel, Mr. Mugo. The affidavits have referred to and detailed. They contain depositions on the matters that, in my view, some matters in my view are not related to this application, and I will therefore confine myself in depositions that directly have a bearing on this application. For instance, the accused has made depositions on the matters touching on her quest for her matrimonial property, a matter that in my view belongs to another forum. The depositions also touch on what transpired from the time the whereabouts of the deceased became a police matter to the time the accused was arraigned in court. On deposition touching on the bail application before this court, the accused deposes that the prosecution has not attached any evidence to the charge sheet to inform her of the case against her. She states that failure to provide such evidence has infringed on her rights under Article 50 of the Constitution of Kenya. She deposes that the prosecution has not provided compelling reasons to persuade this court to deny her bail or bond, and that there is no evidence that she is a flight risk, given that she has voluntarily surrendered her passport to the investigating officers, and therefore she is not in a position to flee the jurisdiction of this court. She deposes that there is no evidence that she will interfere with all threatened witnesses, that she has cooperated with the police during investigations in this matter, and accuses the police of leaking information relating to this case to the media, leading to what she calls her persecution. She also accuses the police of working with the siblings of the deceased to disinherit her. In a supplementary affidavit in response to the two affidavits by Gabriel Anna Cohen Stratton, sister to the deceased, and Dr. Bernard Cohen, brother to the deceased, the accused dwells at length on matters that are not related to this case or to this bail application. I find what is relevant to this application in paragraph 17 of her supplementary affidavit, where she deposes that there is no evidence provided to the court to show that she is a flight risk, to show the nature of the offense and who committed it and or how it was committed, or to show that the deponents will be subjected to physical violence or abduction by the accused, or that both at risk as prosecution witnesses, and that there is no evidence that the accused will interfere with witnesses. The accused further deposes that the sister and brother to the deceased live outside Kenya, and that they are to be released in order to adequately instruct the counsel. Following those affidavits, there were submissions by Mr. Mugo and counsel, who submitted that the prosecution has not provided evidence or annexed it to the charge sheet as the law requires, and that any evidence fabricated after this application will have no bearing on the application itself. We submitted that the law is clear that all accused persons, irrespective of the offense they are charged with, have a constitutional right to be granted bail on bond. We submitted that it is not disputed that the investigating officers have the travel documents of the accused, and therefore the question of her being a flight risk does not apply. We submitted that the matrimonial home of the accused is under the possession of the DCI, who have the key to the home, and therefore the premises are secured. The accused cannot interfere with the same. We submitted that the accused has cooperated with the police in this matter. We further submitted that the accused was not arrested for murder, but for forgery, for which the police have nothing against her, that the accused is being detained without evidence, that the matrimonial home of the accused has not been secured as a crime scene despite the police treating it as such. We submitted that the accused is not a flight risk and is ready to abide by the terms and conditions this court lays down. We submitted that the defense does not have a list of witnesses, and therefore the accused does not know who the prosecution witnesses are and cannot intimidate, interfere, or influence them because she doesn't know them. We submitted that the accused is presumed innocent until there is proof to the contrary, that the accused needs to pursue her matrimonial property in court to ensure that no one denies her the right to that property, and that she cannot do this while in her late husband's business, which business is suffering in her absence. Mr. Murgo told the court that the accused has a supportive family. He informed the court that the accused father, Japheth Kamotho, and mother, Mary Gathoni, were in court during the time the application was being heard. He told the court further that the accused has supportive friends and gave the names of one Mary, Mama Lucy Mwangi and Betty Wemaitha, who are also in court on that date. He submitted that the family and the friends of the accused will accommodate her and account for her whereabouts during the pendency of this trial. Mr. Murgo questioned the manner in which the body of the deceased was discovered in the compound of their matrimonial home, and suggesting that it may have been planted there. He told the court that the police took possession of that home and accused without a court order, and there is nothing to stop this court from giving orders to have the accused repossess her home. In reply to the two affidavits by the siblings of the deceased, Mr. Murgo submitted that there is no evidence by the two that the accused is a flight risk and will abscond from the jurisdiction of this court. He submitted that the two siblings of the deceased do not live in Kenya, and therefore the allegations that their lives are in danger are not supported by evidence. He urged this court to grant this application, submitting that there is no evidence by the two to persuade the court to deny the accused bail. The prosecution opposed the application, relying on the replying affidavit sworn by Inspector Maxwell Tieno, who says he is one of the investigating officers. It is a 51-paragraph affidavit. I have carefully read it. Some of the materials contained in that affidavit are of general nature and do not relate to the bail application before this court. The affidavit gives history of the circumstances leading to the involvement of the police in trying to locate the whereabouts of the deceased and the eventual arrest of the accused. The affidavit further refers to certain persons whose names are not given as the sources of some of the information contained in this affidavit. The relevant parts of that affidavit to this bail application relate to what the prosecution have advanced as compelling reasons why the accused should not be released on bail or bond. And these are enumerated as follows. One, that the accused is a flight risk because of the seriousness of the offense she is facing, that the accused has no fixed abode given that her residence has been secured by the police as a crime scene, that the accused is likely to interfere with witnesses given the nature of this crime, and further that the accused and her agents have attempted to interfere with witnesses, that the character of the accused in demanding to be present during the burial of the deceased and her behavior during the burial caused public disturbance, leading to stone throwing by the public. Further, on the same issue, that her release on bail on bond will disturb public order and undermine public peace and security, as demonstrated by what happened during the burial of the deceased. That the investigations and forensic analysis at the crime scene are still ongoing, and if released, the accused will interfere with the same. That the accused cannot be trusted after she went against the court's orders during the burial of the deceased and addressed the media on issues touching on investigations. In support of this replying affidavit, there were submissions by the prosecution, by Ms. Kishuhi, to the effect that the investigations are still ongoing to trace other persons who may be involved in the death of the deceased, and if released on bond or bail, the accused may interfere with these investigations. She submitted that forensic analysis is ongoing at the scene of the crime to trace more evidence, and therefore if the accused is released, she may interfere with the scene of crime. She submitted that the accused lied to the Netherlands Embassy officials that the deceased had left the country, and that she did not report the deceased as a missing person until 12 days after the embassy had contacted her. She submitted that the consent to have the accused attend the burial of the deceased was to prevent the accused delaying the burial, which would have gone contrary to Jewish rites. She submitted that the accused caused disturbance at the burial of the deceased, as a result of which there was stoning by the public. She submitted that if the accused is released on bond or bail, this will disturb public order and security. It was further submitted that the accused, through her agents, has attempted to interfere with the witnesses, that the prosecution has received information that the defense counsel has been contacting witnesses, which amounts to intimidation. It was submitted that the prosecution attached 2 statements that have been redacted, but the accused still knows these witnesses and is likely to interfere or intimidate them. It was submitted that the offense the accused is facing is a serious one and attracts death sentence, and that the prosecution has strong evidence against her. It was submitted that all these factors will motivate the accused to abscond if she is released. Ms. Kishui further submitted that the accused has no fixed abode and that she has not indicated an alternative residence other than her matrimonial home, which is now a scene of crime. She submitted that she urged the court to find that on a balance of probability and based on the materials presented to court, this court has a duty to protect the integrity of the trial and decline to grant this application. It was submitted that the accused can still defend her succession cause while in custody through a legal counsel, and the court was referred to bond and bail policy guidelines on the relevant authorities. I also looked at the submissions by Mr. Albeta on behalf of the 2 siblings, and also their 2 affidavits. The submissions were that bail is a right that is limited, that is, it is not absolute, and the offense the accused is facing is serious, and therefore the accused may flee the jurisdiction of this court, and that the 2 fear that their lives and personal security as victims and witnesses is not secured, that the accused is likely to interfere with them as witnesses, that if released, this will trivialize the seriousness of this offense, and also that there was an issue of accused claiming that she was sexually harassed, and they said there is no evidence to support that. In his brief submissions, Mr. Beta for the victims also told the court that the Article 49 of the Constitution of Kenya provides for compelling reasons to decline granting bail. He submitted that compelling reasons are not defined, and it was submitted that the deceased had been denied his right to life and dignity, and that the accused has not provided particulars of where she will reside if released on bail. That the matrimonial home is a crime scene and cannot be interfered with, that the accused is likely to flee the jurisdiction of this court, that there is evidence of interference of witnesses even when the accused is in custody, and that the accused may interfere with vulnerable witnesses, and the victims are afraid that the accused and require protection. There was a response by Mr. Mulgo on all the issues raised, and his submissions were that the prosecution has not provided evidence, the prosecution and the victims have not provided evidence to support what they term as compelling reasons. He submitted that the death of the deceased has not been tied to the accused, and the prosecution is trying to frame her. He submitted that the right to bail is enjoyed by all accused persons irrespective of the offense charged. He submitted that the siblings of the deceased have not stated what Inspector Max Otieno deposes in his replying affidavit in regard to accused behavior in forcing her hand in taking part in the burial of the deceased, and that the participation in the burial followed a negotiated compromise between the defense and the siblings. Mr. Mulgo further submitted that the accused did not cause a breach of peace at the burial, but instead it was the politicians who made accusatory remarks during that burial. On the issue of interference with witnesses, Mr. Mulgo submitted that the defense does not know who the witnesses are, and until the witnesses are known, the defense cannot be accused of interfering with them. He submitted that the defense has no problem with the police restricting access to the residence of the accused, so long as there is no damage to that property. He submitted that it cannot be claimed that the accused has no fixed abode when it is the police who has taken over her residence. He submitted that the accused has parents. Her father lives in Lanet in Nakuru, and also has supportive friends whose names were given as Mama Lucy, residing in house number 19 Kileleshwa, Nairobi, and Betty Wamaitha of apartment 1A9 at State House Crescent. He told the court that the accused will reside in those two homes if granted bail, and that the defense is ready to give testimonials to that effect. Mr. Mulgo reiterated that the prosecution has not provided compelling reasons to persuade this court to deny the accused bail, and urged that the application be allowed on reasonable terms and conditions. In support of the submissions and the application, several authorities have been cited, which I've indicated in the ruling. And now I go direct to my determination of the matter. The Constitution of Kenya guarantees certain rights to accused persons. At the stage where we are in this trial, the applicable articles of the Constitution are 49(1)(h) and 52(a), b, and j. Article 49(1)(h) provides the right of an arrested or accused person to be released on bond or bail on reasonable terms, pending a charge or trial, unless there are compelling reasons not to be released. Article 50 is titled Fair Hearing, and this article guarantees an accused person the right to a fair trial, a fair and public hearing. The right to a fair hearing includes, but is not limited to, the right to be presumed innocent until the contrary is proved, the right to be informed of the charge with sufficient detail to answer to it, the right to be informed in advance of the evidence the prosecution intends to rely on, and to have reasonable access to that evidence. The right to a fair hearing or the fair trial under Article 50 cannot be limited, as the Constitution provides. However, the right to bail under Article 49(1)(h) is not absolute and can be limited where there are compelling reasons and there is proof of the same. I have enumerated above what prosecution has advanced as compelling reasons, and in summary form, it was claimed that the accused is a flight risk, that she has no fixed abode, that she will interfere with witnesses, that she will interfere with investigations, that her release will cause public disturbance and undermine public peace and security, that her release will trivialize the trial, and the accused breached the orders of this court by addressing the public during the burial of the deceased. To this reason, the defense has maintained that the prosecution has failed to provide evidence as proof. I have taken time to read the application and the supporting affidavit and supplementary affidavit. I have carefully read and understood the replying affidavit and the affidavits by the siblings of the deceased and all the attachments to all these affidavits. I have read with care and considered all the authorities cited by the parties. I have read the relevant parts of the judiciary bail and bond policy guidelines. It is worth repeating here that bail is a constitutional right that is limited where compelling reasons exist, and this is the thread running through all the authorities cited in this application. What amounts to compelling reasons has not been defined in the Constitution or in any written law. The judiciary came up with the bond and bail policy guidelines to fill in this gap and to guide the courts in determining application for bail or bond. Section 4.9 of the policy guidelines lists what the courts have stated as compelling reasons, and these include the nature of the charge and the seriousness of punishment to be meted out, the strength of the prosecution case, the character and antecedents of the accused person, failure of the accused person to observe bail or bond terms, the likelihood of interfering with witnesses, the need to protect the victim or victims of the crime, the relationship between the accused and the accused persons and the potential witnesses, whether accused is a flight risk, whether the accused person is gainfully employed, issues of public order, peace and security, and also protection of the accused person himself or herself. I've considered the reasons advanced by the prosecution as constituting compelling reasons and resolve the issues as follows. On the issue of flight risk, this court was told that DCI is holding the passport of the accused after she voluntarily handed it over to them. This fact was admitted by the prosecution. This court was not given information to show that the accused holds another passport. This court does not take the issue of flight risk lightly. This is because if an accused person flees the jurisdiction of the court, then he or she cannot attend court in order to face the charges. This would result in compromising the trial itself, and in the case cited by the defense, this is Madegwa case which I've cited above, the court stated that, and I quote, "Bail pending trial is a constitutional right, and the only limitation is when there are compelling reasons not to release the accused on bail. The consideration when the court is considering whether or not to release an accused person on bail or bond is primarily whether the accused will attend court at and during the trial. An accused person is required to be present during the hearing of his or her case, and while granting bail, the court should be satisfied that he will be present. That is to say, the accused is not a flight risk, one who will get outside the jurisdiction of the court and therefore fail to honor his bond terms to attend court during trial." End of the quote. On this point, I find and hold that the prosecution has not provided this court with evidence that the accused will flee the jurisdiction of the court, given that her passport is being held by the police. In ensuring that an accused person attends court, when required to do so, it is the duty of the trial court to carefully consider the matter and put in place terms and conditions of bail that will ensure that this goal is achieved. On the issue of fixed and board, it is clear to me that there is no dispute that the residence of the accused, being plot number LR 2951/449, situated on Faras Lane, Nairobi, has been taken over by the police from the DCI. They are guarding the premises and treating it as a scene of crime. It was argued that the accused has not provided an alternative place of abode. It is clear to me that the accused state of being without abode is not self-created. It is through the actions of the police in securing her residence as a crime scene. It has been argued by the prosecution and the siblings that the accused has not provided alternative particulars of where she will live if this court were to release her on bond. It was also argued that she has not provided information on how she will support herself since she was dependent on the deceased. To respond to this, the accused provided information that her parents are supportive of her and that her father lives in Lanet in Nakuru. She also stated that she has friends who support her and gave the names of Mama Lucy Mwangi and Betty Wamaitha and where they live in Nairobi, and said these are willing to take her in. I have taken these issues into consideration. Indeed, the fact that the accused finds herself without a place of abode is because of the actions of the police to secure her residence as a crime scene. Given that the accused has given some information on alternative places she can reside during the pendency of this trial, it is my view that this is an issue that this court can resolve by putting in place measures to ensure that ends of justice are met. I'll be doing that at the end of this ruling. On the issue of interference with witnesses, this issue has been raised by both the prosecution and the siblings. The accused, through her legal counsel, has maintained that up to this moment, the defense does not have a list of witnesses, and therefore the accused or her counsel do not know who these witnesses are. This is a fact that is not denied. Indeed, during these proceedings, the prosecution sought more time to place some of their witnesses in the witness protection program. On 3rd of October 2019, the prosecution was seeking 5 working days to finalize with the Witness Protection Agency on the protection of its witnesses and to redact the statements of these witnesses. The court declined this application, noting that the prosecution had all the time from 26th of September, when this bail application was supposed to be heard, to sort out the issues of witness protection. It is noteworthy that from that of October today, as I'm reading this ruling, 5 working days have elapsed, and it is my belief that the prosecution has finalized in protecting their witnesses. Having carefully considered this matter, the issue on interference, and having noted that the prosecution has had adequate time to place its vulnerable witnesses in the witness protection program, and that the list of witnesses and their statements has not been provided to the defense, it is my finding, and I so hold, that the prosecution has not provided evidence to prove on a balanced probability that the accused will interfere with witnesses. On the issue of interference with investigations, it is not disputed that a second suspect has been arrested in connection with the death of the deceased and charged under High Court Criminal Case number 65 of 2019. He is awaiting the taking plea. I think we've done that this morning. It is not disputed that the accused was arrested on 28th of August 2019. She has been in police custody until she was arraigned in court on 12th of September to answer to these charges. She was subsequently remanded at Langata Women's Prison. It is also on record that the residence of the accused and the deceased is in the hands of the police as a scene of crime. The police have been in a position to collect all the evidence they required and are still in the position to do so as they are guarding that premises. When I take into account the length of time it has taken for the DCI to collect and preserve evidence, and the fact that they guard what they believe is the crime scene, I can only state that this ground has not been proved. Further, for ends of justice to be met and to protect the rights of all the parties, this court has the powers and discretion to put in place conditions that will ensure any pending investigations at the scene of crime are not interfered with. On the issue of public disturbance and trivializing the trial, I find no evidence to support this allegation. Inspector Otieno, in paragraph 16 of the replying affidavit, refers to unnamed persons as the source of information that the accused and her counsel caused the disturbance at the burial of the deceased. This is not evidence, and Inspector Otieno knows better. Further, it has, especially when the source of that information is not disclosed. Further, it has not been demonstrated that the accused is in a position to cause public disturbance, undermine public peace, or cause public insecurity. Bail or bond is a right that is available to all accused persons, irrespective of the offense. I'm also of the view that other accused persons facing murder charges have been released on bail or bond, and their release did not in any manner trivialize the seriousness of the offense of murder. Finally, on the issue of the accused breaching a court order by addressing the public during the burial of the deceased, it is my view that this matter will be subject to anticipated application for contempt of court, and it is prudent to decline discussing it in this application. The Court of Appeal in Michael Ojuma Oyamo and another, which was cited by the defense, adopted the definition of the High Court in Jackton Malende and 3 others as follows, and I quote, "The phrase compelling reasons would denote reasons that are forceful and convincing as to make the court feel strongly that the accused should not be released on bond. Bail should not therefore be denied on flimsy grounds but on real and cogent grounds that meet the high standards set by the Constitution. End of the quote. In overturning the decision of the High Court in declining to grant bail to accused persons in the same case cited above, the Court of Appeal stated as follows, and I quote, "We must state that evidence as contained in the witness statements before it has been subjected to cross-examination and careful analysis thereafter bears very little weight, unless where an accused person has expressly and voluntarily admitted the contents of the witness statement." End of the quote. This was in reference to the argument that the case against the accused is serious and the evidence is strong. I must point out here that unlike in the case under reference, in this case, the defense does not even have the benefit of witness statements. Despite this, the prosecution and the victim submitted that the case against her is a serious one, attracting death sentence once proved, and further that the evidence is strong. My view is that the same principle advanced by the Court of Appeal in the case I've cited also applies in this case. I wish to state that I have also considered the authorities cited by the victim. This is Republic versus Kunguru Martin Opio and Republic versus Zakaria Okoth Ombado. I have distinguished the two cases with the case before me in that the circumstances were different and the courts in those cases had the discretion to decide as they did. In conclusion, therefore, it is my finding that the prosecution has failed to provide compelling reasons on a balance of probability why this court should decline granting this application. For this reason, it is my finding, and I so hold, that this court has no reason to deny the accused her right to bail in the absence of proof of compelling reasons. Consequently, I hereby allow the application and admit the accused to bail on bond. Having said that, there are certain measures that this court must take to ensure that the ends of justice are met and that the rights of the deceased and the victims are secured. These are the conditions that must be met before the accused can enjoy her liberty pending the hearing and determination of this case. And I enumerated them as follows. Number one, the accused shall execute a bond of 4 million shillings, Kenya shillings. The accused shall provide two sureties, one for 2 million shillings. In the alternative, she can deposit a cash bail of 2 million with the registrar of this court. The accused shall not go anywhere near the matrimonial home, being the reference number I've given there. If for any reason the accused requires certain items from her home or the home she lived with the deceased, which may be necessary from the said premises, the accused shall apply for authority from this court to visit the premises and shall give particulars of what she requires from that premises for the determination and direction of this court. The accused shall not contact, interfere, or intimidate any witnesses, and more specifically the persons who were working under her before she was arrested, whether directly or through her agents. And also not to contact the two siblings, that is Gabriel Hannah Cohen and Dr. Bernard Cohen. The accused shall not set foot or go near the businesses named as Kenya Golf Safaris and Lotus Care Travels or any other businesses being operated by the deceased, whether those businesses were jointly owned with the accused or not, until further orders and directions of the court. Before the accused can be allowed to execute a bond, she shall provide testimonials from her father, Javed Kamotho, and her friends Mama Lucy Mwangi and Betty Wamaitha as proof that they are willing to accommodate her during the pendency of this trial. The accused shall also provide her own testimonial as proof of how she will sustain herself during the pendency of this trial. The DCI shall continue holding her passport until this court makes orders to the contrary, and the accused shall remain in custody now until she satisfies the court on those two directions of testimonials. If you can do that today, the court will go on and make final orders. If not, then we agree on the date when you can come back. Those are the orders of the court.
Do you have an application to make?
Maybe before she makes her application, just the orders given by the court, I have them as execute a bond of 4 million.
Yes.
And then you said two sureties of 2 million. No, two sureties and one of 2 million.
No, two sureties, the total is 4 million. The two sureties, one surety will guarantee 2 million, the other surety will provide 2 million.
And in the alternative to both all
The above is a deposit of cash bail.
Yes.
Is the alternative to all the above.
Yes.
Okay, thank you.
And the other orders.
I think I'm clear on the rest.
Yes,
I have two applications to make. One, I pray that we be present during the surety or bond approval.
Just a moment, please.
One, that the Office of the Director of Public Prosecutions be present during the approval of the bond. Yes. The reason is that, my lady, is that if there's cash amount, we want to ensure that that money is not tainted.
I want to clarify
Yes.
before you proceed.
Yes.
The parties are here to come before me for the testimonials before you go to the DR for approval of bond. So once this court is satisfied with the testimonials, the next step will be now the DR, who is the administrator, to approve bond. That is where you're asking. So you're asking, of course, obviously the testimonials you are going to be present. All the parties are present. Then I want you now to say whether you wanted to be present during the approval by the DR.
Yes. And my second application. Having been dissatisfied with this court's ruling, today's ruling, we are praying for certified copies of the proceedings to date from the first time we came before this court and today's ruling. We are further praying for all the documentation in this file, noting that we have not had anything in regard to any pre-bail report being forwarded to this court. For us to seek redress before the Court of Appeal. My lady, we are praying for the same by the close of today to enable us to go to the Court of Appeal.
You're calling it pre-bail what?
Pre-bail report. There is no pre-bail report on the file, so we are praying to confirm that so that we be availed all the documentation in the file. To enable us seek redress before the Court of Appeal. My lady, the certified copies we are praying that will be provided with the same by the end of today to enable us move to the Court of Appeal as soon as possible. We are taking this, we are requesting for the same, taking note that our paramount duty is to secure the protected witnesses or the witnesses who need to go under the protection, under the Witness Protection Agency. So we need this by the end of today. That is all.
Your Ladyship, I was hoping Ms. Maniki would clarify what she meant by tainted money. We don't intend to use the old notes.
No, my learned friend is experienced. He knows what tainted money is.
No,
it has nothing to do with the old notes.
I did not even put tainted money in my record. I
thought she was joking.
No, it's on a serious note, my lady. My lady, people may laugh, but it's on a serious note. We need to confirm the source of the money.
I did not go there. I wanted us to finish with the testimonials.
Yes.
Then from there, I'll give you directions to go to the DR.
Yes,
for the rest
because
of
it's important. We need to know where the 2 million has come from.
All right. I believe the proceedings were typed up to where we were last time, so it's today's typing. That needs to be done. The ruling is ready. So once that is done, you pursue with the DR. The file will go direct to my secretary to finalize today's handwritten. Then you can get copies.
We will appreciate that, my lady.
Your Ladyship, we on our part will move with the testimonials as a matter of urgency. We hope to be before the relevant court registrar
regarding those testimonials, and we are expecting that we see accused person.
Mr. Mugo, there
Yes.
are two issues. The testimonials are coming back to me.
We are going to make sure.
Then once I satisfy myself,
Yes.
then the file goes to the DIA for execution of the issues on that.
Yes.
Yes.
My lady, for that, can we have copies of them? Because in case we need to investigate that information, it is important because them just forwarding the same, maybe not. The information could be true or not true. So we need copies of the same before this court can make a determination to verify the information that will be given to you.
Your Ladyship, can we have time allocation at 2:30? We will be ready, and we will
Ready
serve
at
them.
2:30?
Yes, we'll be ready at 2:30.
It's not a hearing, Council.
Yes.
It's not a hearing we are coming to. All I need is the testimonials. You need to serve them.
Yes, we will serve them.
Be placed before the court.
And we'll be here at 2:30.
I need to have read them before we come, because all I'm coming to do is a sentence.
maybe by 2 o'clock
Release?
they will be filed, and so that at 2:30 will go, because they'll be short.
Fine.
These are very simple folk, and they are Kenyans, as Kenyan as Ms. Moniki, as Kenyan as me.
It will not be difficult to ascertain that they are bona fide.
Do you also serve her?
We'll serve her by 2 o'clock.
Prosecution, yes.
My lady, we come back to 30. That 30 minutes is not enough for us to certify the information.
Let's come back to court at 3.
That's all right.
Yeah, but please let me just say, I just want to satisfy myself. It's not a hearing I'm opening. The orders I've given are clear. Okay?
My lady, in fact, that is where we are having a focus. The Procedural report, we need, if they say they live in Nakuru, we need to certify they actually live in Nakuru. Plot number, we need to confirm. But we leave it to the court, but that is our prayer, that we be allowed to verify the information that is being given to the court.
Mr. Murgo, don't think it would have been better to come on Monday. I know the days under which
Your Ladyship will come at 3. If they oppose, which we
Expect them to oppose, we will expect the court to deal with it. They have offices in Nakuru, DCI has offices in Nakuru, NSIS has offices in Nakuru. This is the digital age. Holding people in custody in such circumstances is both warranted, cruel, and unnecessary.
Okay, I've been treated here at 3 p.m. I come back. I need to have seen them cancel this
Yes.
So if you could have them filed before, or at least the latest by 2, so that I have time to look at them. Let's enjoy the court.